Hello visionaries, welcome back to my channel. My name is Maresa Talbert. I'm the founder and CEO of Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law.
My faith rising. I'm crawling out the trenches, holding me.
I have another viewer comment that I would like to address today. The question that one of my viewers asked was, can a nominee service create privacy protection for a business owner as an alternative to registering the business in one of the anonymous states, such as Delaware or Wyoming? And I thought this was a great question, so I wanted to address it more broadly. Let's jump right into it. You already know, we got to start from the top. So what the heck is a nominee? A nominee, according to the IRS, is someone who is given limited authority to act on behalf of an entity, usually for a period of time and usually during the formation of an entity. In its simplest terms, a nominee is the name of a person or business that you use on the public documents for your business. So instead of placing your name on the filing documents, the nominee's name would be used. So now the next question to answer is, who can be a nominee? And really, any person can be a nominee. It could be a family member, it could be a friend, it could even be your attorney. So that was easy, right? Hire a nominee, put someone else's name on the public documents, and you're good to go. Done, right? But here's the flip side. When you form a business entity, most states require you to list the names and the addresses of your members, managers, directors, and officers. And these filings are required annually. So for example, in California, after you filed either your articles of organization or your articles of incorporation, you then have to file a statement of information within 90 days. That statement of information has to list the specific information for the actual owners of the business. And the same is true for most states. So essentially, the level of privacy that you thought you were getting by hiring a nominee goes out the window. It doesn't even matter anymore. Another issue that can occur with nominees is the fact that you've listed the nominee as the legal owner of your business. And while the idea is that the nominee has no power over your business, in theory, in real life, and legally, they are the legal owner of the business. And let's not even get into the fact that most people that I've worked with do not have sufficient contracts for their business transactions. So if your contract with your nominee is not up to par, you could be in for a real treat. And I mean a real nightmare. Your nominee could decide to turn on you and exercise the inherent power that they have by being listed as the legal business owner. Your nominee could be badly injured or could even pass away, and that could cause their heirs or members of their family to try to claim rights upon your business. There are just a lot of reasons why using a nominee could be a very risky undertaking. So if you plan to use a nominee, really think through those pros and cons. Make sure that you give it adequate consideration and make sure that you have a bulletproof contract in place with the nominee so that you can avoid the worst case scenarios. Well, that's all I got. I just wanted to present that question for consideration because I thought it was a great question. And I hope I've given you something to think about. Again, thank you so much for watching. As always, this is Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law. I'll see you in the next video.
I done made it this far. I'ma keep it pushing, yeah. Even made it through the